evening again. Welcome to this very important event. And this applies to all these people who I don't know where they are behind the screens. It is an important event because we're going to contribute the possible reform of the Arbitration Act. And I hope those who are behind the screens can persevere until we finish. Anyway, you all know me, but those behind the screens may not know me. I'm Aleka Shepherd, and in my role as a chairman of the LSLC and then as an arbitrator, I have always been supportive of reform in the law when there is a compelling need for it. Whether there is a compelling need to reform the Arbitration Act, we will debate it this evening. The Law Commission, I think, has given us an ammunition to think. Its consultation paper is commendable for its clarity and thorough research. Our splendid panel, our superstar panel, as you hear in GB News, will debate the issues and then they will advise or discuss whether the recommendations of the Law Commission need an answer to yes or no. And I hope you all contribute, and you, the people behind the screens, please put your questions across and your views. So it remains for me to introduce our distinguished chairman. Sir Andrew, as a judge of the Commercial Court, deals regularly with arbitration applications of any kind. He's currently coordinating the court's intended response to the Law Commission paper. Sir Andrew is an example of admirable achievement, and I mean this. He followed a rare path to the judiciary. First, he practiced as a solicitor and a partner with Linklaters for 16 years. He then joined the bar and practiced from Brick Court Chambers for 19 years. He was appointed as a QC, as it then was, in 2013, and as a deputy High Court judge in 2017, and as a judge in 2019. If any solicitor here or anywhere dares to follow the same path, here is your mentor. Over to you, Sir Andrew.
Thank you very much, Aleka, for that kind introduction. I will just mention that this morning I went to the swearing in of Lady Justice Falk, another former solicitor who's just become a member of the Court of Appeal. So it may become a well-trodden path. Welcome to everybody from me too, including everyone who's attending remotely. I'm sure it'll be a fascinating and useful event. May I introduce our distinguished panel? First, Sharina Pettit on my far left is a partner at Norton Rose Fulbright. She's an international arbitration lawyer and leads the practice across Asia, Europe, and the Middle East, in addition to leading the firm's India practice. Her practice areas include trade, transport, oil and gas, and commodities. Sharina regularly sits as an arbitrator and also has significant experience in investor-state dispute resolution. Next, Poonam Malwani, KC, to my immediate left, is head of Quadrant Chambers. She is a commercial silk with a broad practice and has worked in a wide range of arbitration cases, including under the LMAA, LCIA, and ICC rules, and of course, arbitration-related cases in the commercial court and appeals. Her practice areas include shipping, shipbuilding, insurance, and other commercial disputes. To my right, Philip Hopkins is a QC specializing in commercial dispute resolution. She practices both as a barrister from Essex Court Chambers and as an arbitrator based at 24 Lincoln's Inn Fields, and has experience in shipping, admiralty, and international trade cases. Philippa is a member of the Commercial Bar Association's working group, which is currently considering and preparing a response to the Law Commission's consultation paper. And then finally, on my far right, Sir Bernard Eder is a full-time arbitrator practicing from 24 Lincoln's Inn Fields. Before that, he was a High Court judge sitting mainly in the commercial court and practiced as a barrister for nearly 35 years in commercial litigation and international arbitration. Among other international roles, he is a judge of the Singapore International Commercial Court. We also have with us in the room Dr. Nathan Tamberlin, Associate Professor of Common Law at the University of Exeter, who is one of the main authors of the Law Commission's report. I know I'm speaking for the whole panel when I offer our congratulations on an extremely well-written, thoughtful and thought-provoking piece of work. You're very welcome this evening. So as you all know, the subject under discussion is key aspects of the consultation paper. The consultation period ends on the 15th of December, and many of you here are likely to be involved in considering and perhaps making responses to the consultation paper. Events like this are an invaluable chance to share views and learn how people from different sectors using arbitration regard these questions. We're going to try and focus on 7 of the major topics, and so we'll take them in turn. I'll first give an extremely brief outline of the Commission's proposal, and then I'll invite I gather I'm too quiet. Can you hear a little better now? I'm going to take each topic in turn. I'll give a very brief thumbnail sketch of the proposal, and then I'll ask one member of the panel to lead off asking a few questions along the way. And at the end of each little mini section, I'll invite questions from any of you or anybody who's participating remotely. And of course, other members of the panel may chip in as well. I'll look out in the chat box for questions coming in from remote participants. I can't promise there'll be time for everyone's questions because we do have a lot of topics to cover, but apologies in advance if I don't get to your question. There will be a chance afterwards to continue some of these discussions over drinks. So without further ado, I shall turn to the first topic, which is discrimination. Now, here the Law Commission proposes, briefly, first of all, that the appointment of an arbitrator should not be susceptible to challenge on the basis of the arbitrator's protected characteristics, and that's using the Equality Act definition. And secondly, that any agreement between the parties in relation to the arbitrator's protected characteristics should be unenforceable unless, in both cases, that is a proportionate means of achieving a legitimate aim. So I'd like to start with Sharina on this topic, and perhaps you could just begin by giving an indication of how often you encounter clauses that do call for protected characteristics and what type of characteristics they tend to relate to.
Thank you. Can everyone hear me? Is that all right? Thank you. I wanted to actually start by commending the Law Commission, and I do think that this is a world-leading initiative. It's set out in the, these are the words that they've set out in the paper, and I think it is world-leading. I don't know any other national legislation that has come out with something like this. And as you suggested, it suggests that that arbitrator appointments should not be challenged on the basis of protected characteristics, and that any agreement prescribing that an arbitrator has or does not have such characteristics is unenforceable. I mean, that is quite a strong word, which is unenforceable. But there is a caveat there. Unless in the context of the arbitration, of that arbitration requiring the arbitrator to have such protected characteristics is a proportionate means of achieving a legitimate aim. Again, really important words, legitimate aim. So what are the proportionate characteristics? And I think before I go into the examples, I just thought, under the Equality Act, what they're referring to is age, gender reassignment, being married or in a civil partnership, being pregnant or on maternity leave, disability, and this is really important one, race, including color, nationality, ethnic or national or origin, religion or belief, sex or sexual orientation. So that's the characteristics. In terms of the clauses on protected characteristics, in my experience, I haven't really come across most of these except for the nationality characteristic. And that's there in the different arbitral rules, the ICC rules, the LCI rules. They have the carve out in there, mainly for the precedent of the tribunal or the sole arbitrator. What I have come across is the, as I said, the nationality. But the other type of discrimination that obviously that has not been addressed, but that I have come across, and particularly in, because I do a lot of work in India, is carve-outs for retired judges of Indian origin to be in arbitration clauses. Now, that's not discriminatory as per this, but it is because most of the judges in India are men. So effectively, what does that, if you have a clause there, to me, that's pretty discriminatory. And that is actually what's led to a very small pool of arbitrators in India, being a pool of people, men in India, basically leading arbitration. There is a lack of diversity in the world. And I think I would say before the pledge was launched in 2018, there was a serious lack of diversity. And I was looking at some numbers. And according to the ICC, in 2021, just 17.5% of arbitrators nominated by parties were women, and 26% of arbitral tribunal chairs nominated by co-arbitrators were women. So although these statistics are dismal in the grand scheme of things, actually that has been a huge progress. And I think a lot of it is thanks to the pledge. And therefore, I think legislation like this is needed because someone's got to do it. And I'm glad we've done it. Well, hopefully it will come through.
You mentioned that you've quite often seen nationality clauses. And I suppose parties may feel that by stipulating that an arbitrator should not come from either of their countries or perhaps should come from a named country, that gives some at least perception of impartiality. Obviously, the proposal includes the proportionate means defence. How would you see nationality clauses stacking up against this type of rule if it were introduced?
I mean, I think the Law Commission has got the caveat exactly right in the sense that, the law should only permit provisions regulating an arbitrator's nationality if this helps achieve a proportionate and legitimate aim. And I think those are really important words. They're wide enough, but they're important enough. And I think that's where they've kind of tried to get the balance right. And any other infringement on an arbitrator's protected characteristics is unacceptable. And I think that kind of tallies quite well with the institutional rules as well, with the ICC, the LCIA, and that's the direction that the world is going in. So I think as long as there's a legitimate aim, and if you look at the Middle East and you look at Southeast Asia, sometimes they are, there is a much more conciliatory approach where they feel that they would want an arbitrator to come in because of that kind of an approach, as opposed to countries like the Western world, which is much more sort of dogmatic and process driven. So and that's where I think the balance is right.
And the Law Commission, of course, touches on the question of whether enforcement may be affected by this sort of provision. Do you have a thought on that?
I think that is, I mean, you know, I think the Law Commission has acknowledged that that is going to be an issue, but someone has to take this first step, and they've done it. They've, you know, yes, there's Article 5.1d of the New York Convention, which basically states that one of the grounds for resisting enforcement under the New York Convention is that the composition of the arbitral authority or the arbitral procedure was not in accordance with the agreement of the party. So obviously this suggests, for example, a party could resist enforcement of an award if the arbitration agreement specified that the arbitrators would be a man, and when in fact a woman was you know, appointed. But really, ultimately, you'd go to the court for that. And how many courts are really going to uphold something like this in today's day and age? So I think, and I don't think the Law Commission, I think they know that this is going to be a problem with the New York Convention, that there are going to be challenges. But what they have said is that, you know, it is more important that the law in England and Wales takes a stance against discrimination. I mean, those are powerful words. And that it is in the public interest to end discrimination against people on the grounds of their protected characteristics. Again, powerful words. And, you know, if someone doesn't take the step forward, no one's going to. And I think we'd probably see other countries following suit.
Thank you. Would any other panel members like to add to any of that? Any questions from our audience on discrimination? Yes.
How would it work?
Oh, we have a roving mic.
How would this work if you have, say, a family contract settling a dispute about property, and it provides for arbitration by the Beth Dean, a Jewish court? Is somebody going to be able to object? Well, there's no particular reason why this particular dispute needs to be dealt with by rabbis.
I mean, that's interesting. And again, with that, you know, where does, I mean, I guess, does that, the argument would be, is that in the legitimate interests? And if it's not, then there's that will lead to the challenge.
I mean, what I'm afraid of is it's going to spawn satellite.
Yes, and I think that when they probably considered putting the caveat in, they probably were aware of that. But the point is, if you don't take the first step, how are you going to get anywhere?
I mean, as far as the proportionality test is concerned, I mean, the question might arise about what is meant by a proportionate means in the context of that arbitration, and whether that refers to the particular contract, or whether it can be approached generically simply by reference to looking at the position and concerns of the parties to the contract.
And it might spawn satellite litigation. If the parties have stipulated in your example for that, it shouldn't be too tricky for them to put forward evidence in a reasonably limited and cost-effective, proportionate way as to why it is or is not appropriate to have someone with that background and history to deal with their dispute. And we'll see over time, I suspect the satellite litigation diminish. I agree, it depends dispute by dispute, but at least umbrellas will have developed of what is and isn't a proportionate subject matter that requires someone of a particular ethnic or religious background. So a little bit of satellite litigation shouldn't put us off the rather more laudable aims behind this.
Yeah.
Any other questions? No. All right. Thank you very much. Well, we'll move. Sorry. No, that's simply to do with audibility. We'll do our best on that. Right. The second topic, interim measures in support of arbitration. I mean, there are several limbs to this, but I'll mention two in particular. One is that the Commission considers that the court already can make Section 44 orders against third parties in appropriate cases. but asks whether this should be made explicit in the Act. It suggests that third parties in that sort of case should have the full right of appeal, not the restricted right available to arbitral parties. And then the second limb I'll touch on is to do with emergency arbitrators. And in order to cater for cases where an emergency arbitrator makes an order but the parties ignore it, the Commission proposes two things. One is the court having a power to order compliance with a peremptory order of an emergency arbitrator. And the other option is allowing an application to be made to the court under Section 44(4) with the permission of an emergency arbitrator. So perhaps I can ask Philippa first, dealing with the first point, first of all, whether you think it would be desirable to have a clarificatory provision about orders against third parties.
Yes, absolutely. Can everybody hear me? It's not usually a problem. So it's fair to say, I hope I'm not being unkind to say that Section 44 is something of a mishmash section, and possibly reflecting that this section of the report, the one that deals with Section 44, contains something of a mishmash of proposals. They're a little bit disparate, but I think that just reflects what Section 44 is and how it works. Andrew's mentioned first the question of orders against third parties and the proposed reform to Section 44, subsection 2. As I'm sure you all know, it's no doubt at the forefront of your minds, Section 44, subsection 2 sets out the types of interim orders that the court can make in support of arbitrations, and that's both English-seated arbitrations and arbitrations overseas. So to that extent, it's quite broad. And one of the questions that has come up is whether some or all of the subsections under Section 44(2) allow for the making of orders against third parties. That's to say, parties who are not parties to the arbitration agreement. And it's fair to say that that is something of a running sore, that question. The Law Commission, in its report, says that they think those orders can currently be made against third parties under all the sub-paragraphs of Section 44(2). I'm not sure I entirely agree with that. I don't think the Court of Appeal quite agrees with that either, which is perhaps more important than what I think. But in a way, that's a sideshow, because what is important is not what the law is now, but what the law should be and whether there should be an amendment. My view, to answer the question that Andrew posed at the outset, is that I think it is a good idea. I think there ought to be an amendment to Section 44(2) to make clear that there is a power to make orders against third parties. I know some people will think that that's not right, and they will think that that involves going too far beyond the scope of what is required in support of arbitration. It's also fair to say that if the courts were to get overexcited about the exercise of such a power, that could be seen to be rather intrusive and there could be problems. But my view on that particular point is, yes, it should be made express. I certainly don't think it's sufficiently clear at the moment on the state of the law. I was going to pick up just three other disparate points relating to Section 44. The first is what the Law Commission are proposing to do in terms of repeals, because they say that Section 44(2)(a) should be narrowed, and they say that Section 44(5) should go, supposedly because they are surplusage. The suggested amendment to 44(2)(a), which permits the court to make an order for the taking of evidence of witnesses, is to make clear that it only relates to deposition evidence. And the reason that that is suggested is that Section 44(3) deals with witness summonses, albeit subject to particular conditions. Now, in my view, the difficulty with the proposed amendment is that it risks throwing out powers that are or that may be quite useful. For example, as I read Section 44(2)(a) as it's presently drafted, it permits the court to order that a witness provide a statement or affidavit, for example, an affidavit of assets. And there are times when that could be quite handy, and soundings among the commercial judges suggest that they think so too. I'm not sure that the implications of fiddling with section 2A, subsection 2A, that's a slightly harsh way of putting it, perhaps changing it would be better, have quite been fully thought through. And I also think that given that all we're talking about is dealing with surplusage, one's got to be a little bit careful. If you change something that isn't really broke, there's a risk that you will come up with unforeseen consequences. And I think that might be a problem. I think there are potentially similar implications in relation to repealing section 44, subsection 5, which is also being proposed. I think that might be a little bit more profound than is currently suggested. The third point is emergency arbitrators, which you've also mentioned, Andrew. The Commission suggests that the Act shouldn't be amended generally so as to apply to emergency arbitrators. My view is that that is right and that it shouldn't be. The emergency arbitrator, of course, postdates the 96 Act, and he or she is really a creature of the big institutional rules. The parties should be allowed to sign up to rules like that if they want to. If they don't want to, my view is they shouldn't have to have anything to do with that. Do the orders of emergency arbitrators need to be enforceable by the court? And is an amendment needed to do that? I'm not sure any amendment is needed. In an urgent case, which could and often would include a party not complying with the order of an emergency arbitrator, then the court can act under section 44. If the case isn't an urgent one, I question whether there's any role for the court at all. The emergency arbitrator is a temporary creature. The idea is that he or she will be replaced by the properly constituted tribunal. If an emergency arbitrator's order isn't being complied with and the tribunal's in place, well, you go to the tribunal to get them to sort it out. So I'm not sure that an amendment is needed there. The last point I wanted to touch on is actually a point that isn't in the paper at the moment. It's something about section 44 that the proposals don't cover. The Commission, at the moment at least, is not suggesting revisiting sections 44.3 and 44.4. And 44.3 is an interesting one and has caused a bit of difficulty in practice, I think. You will no doubt recall that it allows the court to make an order in an urgent case, but only where it considers it necessary to do so for the purpose of preserving evidence or assets. Now, on its face, that's quite a narrow provision. The courts have dealt with it by stretching that wording, perhaps to breaking point. Some might even say beyond breaking point. And they've done that in particular by putting a very wide construction on the words preserving evidence or assets, so as to include preserving a right under a contract and even sometimes a disputed right under a contract, though that is more controversial. And of course, that's the Settlem and Roost line of cases. There are others as well. Singapore has taken a slightly different line on that from the English courts. There are arguments for keeping section 44.3 very tight, and there are arguments for relaxing it a bit more. I'm not sure I know the answer, but I think it's interesting. And I just wonder whether that's something that the Commission ought to be looking at as well. That's all I wanted to say for now.
Let me just ask, on emergency arbitrators, do you think there may be situations where it would be useful for an emergency arbitrator to be able to make a peremptory order, which could then be backed up if necessary by the court?
Conceivably, but I just wonder how much scope there is for that. The court can intervene itself if it's urgent and make its own order under section 44.3. Once the tribunal is constituted, the tribunal will have the power to make peremptory orders, which can then be enforced under the Act. It might add something, but I just wonder if that window is a little small.
Mm-hmm. All right. Any other contributions?
I wonder if we can ask Nathan why he didn't consider a change to section 44.3. Because for those of us in practice, it is the most irritating provision because we have to keep stretching it. But if we're not allowed to ask you, I'm sorry.
And on, I should say, on ex parte applications, sorry, Nathan, I've cut you off. On ex parte applications, one has to go through the whole full and frank disclosure business saying there is this line of cases. it's probably okay for you to make an injunction, order an injunction, my lord, because I think I've got an asset that is a right under a contract.
Yes.
But there's this line of cases that says if the right is disputed,
Yes.
it might be a bit tricky.
Yes.
And in Singapore, they're doing something different. And I'm just telling you this because I'm going ex parte, so I have to. And it's
Yes,
Not
I
ideal.
think it would be a little unfair to put Nathan on the spot in plenary session unless he wants to.
I mean, the answer is quite simple, which is that no stakeholder raised it with us prior to the consultation paper. We did receive well over 100 suggestions for reform, pretty much touching on every section of the Arbitration Act. And given all of that, we didn't go fishing for anything else that wasn't raised. But one of the questions in the consultation paper is there any topic that we haven't discussed which you think needs to be discussed? So if that goes in as your official response, then it will get considered. I can't put it any higher than that until we see it, but it will get considered. So there's still an opportunity for new things to be suggested.
I think you may see some sight of it, potentially in the Combar response at least.
I'll add my name there.
But it seems there will at least be answers to that question in the consultation paper. Let me just ask Philippa one other thing in this area. You mentioned section 44.5 as an example of something that perhaps doesn't need to be changed. If that sort of provision, which is really designed to restrict the court's intervention, is taken away, do you see any risk that that might be seen more widely as a hint towards greater court intervention?
I think that's exactly the risk. I think there are jurisdictions where there is a concern that the English court intervenes too much in arbitration. Practitioners know that it doesn't, and sometimes we feel we'd like it to intervene a little bit more. But I suspect that internationally, the idea that you're repealing a section which was included as an express indication that the court is not going to intervene too much is not a good look. Bernard was saying earlier that he finds when traveling that in some jurisdictions, people are saying, oh, well, don't go to London to arbitrate. The courts intervene too much. If you remove a subsection that appears to say the court shouldn't intervene too much, I think it really might send a dangerous message.
Right, thank you. Any questions from audience members? Yes.
You mentioned about Singapore, the different positions. Are there any merits in that positions?
I think there is potentially a merit in the Singapore position. Just to be clear, there is a decision of, I think, the Singapore Court of Appeal, from memory, which says that the court should not intervene in granting relief under Section 44, or should at least be very slow to intervene, where there is a dispute as to the existence of a contractual right. The view taken in the courts here has been that in an appropriate case, and even where the contractual right is disputed, it may be possible to intervene. Now, one can readily see the difficulty with that. It's absolutely fine if there's a clear right under a contract and everybody knows that there's a right which can be enforced. For example, a right to arbitrate or a right to litigate in a particular jurisdiction, and that's often what we're talking about. But where the very existence of that right is disputed, it's a bit more problematic, I think. So yes, there may be some merit in the Singapore position. Again, I think it's something that deserves a bit of ventilation. If the wording of the subsection were different, the position would be clarified, and it could be different in terms of being wider or different in terms of being narrower.
Thank you very much. Any other questions or observations? No. All right, thank you very much. Well, we'll move on to another topic. I suspect quite a hot topic. Jurisdictional challenges against arbitration awards. So here the Law Commission proposes that where a party has participated in arbitral proceedings and has objected before the tribunal to the tribunal's jurisdiction, then any subsequent court challenge under Section 67 should be by way of an appeal, a review, in other words, not a rehearing. And that the same should apply to applications under Section 32 to question or determine the tribunal's jurisdiction, but on the other hand, that there shouldn't be a corresponding change to section 103 of the Act in relation to incoming awards. So I'm going to start with Poonam, and perhaps if you don't mind, I can begin by asking you whether you think it is unfair for a party to challenge jurisdiction before the tribunal and then subsequently to seek to challenge jurisdiction in court, and whether it makes any difference that the merits and the jurisdiction issues may have been dealt with together by the tribunal.
Okay, if I deal first with where it's just jurisdiction, because life gets trickier when there's merits and jurisdiction. Yes, it's unfair because it's two bites of a cherry. And that's not something we normally allow in our business. I mean, to be clear, the Law Commission's proposal is only to change the rehearing to an appeal where the party has participated in the arbitrator's jurisdiction award. If you don't participate at all, then subject to having not waived and complied with section 1772, you can still challenge the award under section 67 under the recommendation by way of a full rehearing. But if you've participated, the Commission recommends it should be by way of a normal appeal. And it is unfair because right now, the rehearing is, as I said, a second bite of the cherry. Miss Justice Gross, when he was Miss Justice Gross, described the arbitrator's award as a provisional award. And the Supreme Court in Dahlia, when they looked at the position under section 67 and also under section 103, which we'll talk about, said, well, you might look at the arbitrator's reasoning and expressions of view out of interest, but in no way trammels the court, nor does the witness evidence. It starts again. And in 2016, at the 20th anniversary of the Act, the LSLC had an event, Bernard, I don't know whether you remember, it was, we had to speak on different topics for 5 minutes, and you terrifyingly held green cards and red cards up as we were reaching the end of our 5 minutes.
When I was very young.
I was even younger, it's terrifying.
Younger still.
And funnily enough, I spoke about section 6. And I said it was outrageous that it needed to be reformed. And I did some statistical analysis then. And in 2015, there were 5 section 67 hearings in the commercial court that involved witnesses of fact and expert witnesses giving repeat live evidence. And when I say repeat, of course, that's what potentially makes it unfair. It's not repeat, it's further and better. You've learned from your mistakes, you've had a little guidance from the tribunal about where your evidence fell short, say your cross-ex is a little better and a little tighter and you don't stray where you went wrong, etc. on the witness's side. And on the legal side, you may have had an argument shut out, a legal argument before the tribunal, because you raised it too late. Not because you suppressed documents, and just procedurally it was a bit late, but get to your section 67 rehearing and you can run that up. So yes, potentially unfair and wasteful of court time, as it was then. So when I first read the report, I was very excited and I thought it was absolutely right. However, thinking about the point to do with merits awards as well, when you're going to have jurisdiction and merits, what slightly changed my mind since Friday, sorry Nathan, is I'm concerned about non-participation. It's one thing to say that if the tribunal is dealing with jurisdiction, well, then you don't participate, you get your full rehearing. But perhaps not so often in our world, where the jurisdiction debate might be very big and very time-consuming. But in a lot of arbitrations, I suspect, they are going to deal with jurisdiction and merits at the same time. And if that's the case, then what does the party who doesn't want to participate in jurisdiction because it wants to keep its full rehearing, section 67, right? What does it do about the merits bit? That it doesn't participate. So that's not going to work. You don't want to encourage non-participation. And if they're going to make submissions to the tribunal, if they could, without it being a submission, that the tribunal should only deal with jurisdiction and not merits, because otherwise it would be unfair. And if the tribunal were to accede to that, then you're going to have situations where the tribunal would normally have dealt with merits, i.e. you're getting this speedier resolution that we're meant to want from arbitration. And you're going to have that speedier resolution delayed, with the tribunal then bifurcating jurisdiction and merits in a situation where they would otherwise have dealt with them together. So there is a problem for me with the proposal in light of the fact that tribunals will often want to deal with jurisdiction and merits at the same time. So I can't believe I'm saying I think possibly it should change, but I need to find a way around this little conundrum.
Do you see a scope for dealing with some of the problems of unfairness and perhaps certainly the practicability problems by the way in which a rehearing is done? For example, not necessarily having to hear all the witnesses again if the court, as part of the management of the process, comes to the conclusion that either the evidence from the witnesses is perhaps of tangential relevance and can be taken from the transcript, or powers of that kind?
In short, no. But first, there's one thing important to remember is there is, to my mind, the excellent provision in the Commercial Court Guide now that the court can essentially, on a summary judgment standard, dismiss a Section 67 as hopeless. On paper, the party who's lost that can challenge it, demand an oral hearing, but if they lose it, indemnity costs, etc. So there is now a summary way to get rid of bad Section 67s. And I did look at the stats, and the number of 67s has diminished substantially over the last 6 years from when I looked at it in 2015. I think it was 15 last year and 15 to middle of 2020, 15 to middle of 2021, whereas back in 15 and 16, it was like 40s and 50s or something. So there's been a substantial reduction in the number of Section 67s. So that's good. But if you're going to get there, if you haven't been chucked out for being summary judgment rubbish standard and you're going to have your Section 67, then no, I don't think you should chip away at the right. If it's a rehearing, it should be a rehearing. The court can have its normal powers to say it shouldn't take more than 4 days and the cross-ex only for half a day or whatever. But I don't think you can have some halfway house of it's a rehearing, but I'm not going to rehear that bit. That seems to me unsatisfactory and also going to lead to squabbles. And the really boring trying to read transcripts to work out what people really meant in that.
Well, we're always going to have squabbles.
That's true. So no, in short, no, if you're going to do it, let it be a rehearing proper.
Thank you. Do you have any take on how this is dealt with in other jurisdictions?
Yes, I mean, as the Law Commission report explains, most of the Commonwealth countries do a rehearing, and that's because they have endorsed and followed the Supreme Court decision in Dahlia that says it's a rehearing. So I'm not sure whether it's independent thought process. It's following what we've done here. France does a rehearing, etc. But there are some that do not. Singapore says it's a rehearing, but they only allow new evidence if you effectively satisfy Ladd and Marshall. And in the States, the Law Commission report refers to the fact that there is an appeal to the Supreme Court, or whatever the right phrase is there, about whether it should be a rehearing. So we might be out of step if we changed with some of the jurisdictions, but only because they followed what we did before, and now we're having further and better thoughts and changing, and then they might well follow us. So yeah, mostly rehearing everywhere else, but we can lead the way with the change.
Thank you. And other panel members, any thoughts on that?
Could I just add a word? I think that the biggest question in the Law Commission's report is whether we should amend Section 67. On most other topics, I think there are different views. But I think whether the present situation is unsatisfactory. So when I was a judge in the commercial court, I'm just trying to remember, but I think there was a hearing before arbitrators. I think it lasted 10 days. I think I was told it cost $1 million or pounds or something like that. And then the arbitrators reached a particular conclusion. I can't remember what it was, a reported case. And so they come before me on a de novo hearing. The parties kindly agreed that they would forego the delight of calling all the witnesses again, and that I could read the transcripts, but it was all about credibility. So I then sit in a little room for 3, 4, 5 days reading transcripts, and actually I reach a conclusion different from the conclusion reached by the arbitrators. And there's another judgment by Mr. Justice Flo in another case where he had a similar experience. That is not a very satisfactory way of dealing with it. Equally, as Poonam says, the idea that all the witnesses do come and give evidence again and are cross-examined again is not very satisfactory. The real difficulty is trying to work out what is satisfactory, and on that I'm not sure at the moment. The suggestion by the Law Commission is one possible option. I've just come back from an earlier meeting in Parliament, actually, where Lord Mance spoke, and the problem is he says that it's a matter of principle, in the sense that if the tribunal does not have jurisdiction, then it cannot itself decide that it has jurisdiction. It's a competence principle, which most English lawyers adhere to as regarding, well, that must be the obvious answer. Anything further is ridiculous. And any restriction on that in terms of the evidence that you might be able to adduce in a court it goes against that fundamental principle. I discussed with Andrew earlier, well, can't it all be dealt with by case management powers? And Toby Landau, who also spoke this afternoon, his view is, well, it can all be dealt with by case management powers. So you control whether new evidence can be given. You control whether new documents can be adduced. You control whether or not live evidence should or should not be adduced. I'm not sure that really deals with it. Well, one party comes along and says, I've got 6 witnesses and I want to call them. It's very, very important. Maybe the court can, in the exercise of its case management powers, deal with that. So I'm not sure what the answer to it is, actually, but I am pretty sure that the present system is not very satisfactory.
Any questions from audience members? Or thoughts? Yes.
Does anyone have any views as to whether Poonam's problem could be dealt with by providing expressly that a party has a right to take part on the merits without prejudice to jurisdiction, so as to preserve their right to have jurisdiction dealt with by the court, but not to be forced to take no part on the merits?
So to deal with my concern, where the tribunal is going to deal with jurisdiction, but it's also decided it wants to deal with merits at the same time. You go with the Law Commission proposal that as long as the objector does not participate in the jurisdiction side, that's their choice, and they can have a rehearing. But that doesn't put them off participating in the merit side, because we provide the act where you've got this dual thing, you can take part in the merits bit without having submitted to the jurisdiction on the jurisdiction bit. Got it right, is the idea? Yeah.
Now, how did it work if the jurisdiction and merits issues are the same, as they can be occasionally?
Such as the existence of a contract
Yes,
at all,
often
for
acceptance
example.
cases, yes. Or intention to create legal relations, yes. Then they're combined. So the logic of that approach would have to be, I think, that you are not barred from a rehearing in court. because you had done no more than was necessary to preserve your position on the merits.
That must be right, yes. And if there was some freestanding additional point on jurisdiction, you wouldn't be able to take that. But if on the merits point, you've argued it, you can still. That's really weird, wouldn't it? You could rehear under section 67, but only 69 it on the merits bit. But that happens now. Anyway.
Yes.
I'm afraid I'm rather with Lord Mance on this one. I can't, in my head, get past the point of principle. Although, like Bernard and like Poonam, I recognise that there's a real problem with what was going on, what is going on. And anyone who has been involved, as probably most of us have, in a contested Section 67 rehearing in the commercial court, it's not ideal.
No.
It's not ideal. I will be really interested to see how what I think is a new power really in the commercial court guide beds down. That's to say the summary dismissal provision in the guide, because that wasn't there until the current edition. It was there for section 68, but of course that is different conceptually. It's now in for section 67. Is that going to shut out a lot of these applications? Remains to be seen, I guess, but it might.
Because there are so few anyway.
Philippa, if you've got under the proposal the chance to have your section 67 full rehearing if you don't participate, but you choose to participate, it's your choice, doesn't that give the stamp of approval from you to the tribunal to decide it on terms, not that they're the final arbitrator, because you've still got your right of appeal, but on the basis that it's subject to the right of appeal rather than rehearing? And so doesn't that get round Lord Mance's concern, because the party's given it that stamp and agreement?
That assumes that everything is going to go swimmingly and that you have no concerns that if the arbitration hearing in which you've not participated goes against you, the award which will then exist will not somehow be weaponized elsewhere in enforcement. I think it's an invidious choice, the idea that you have to participate, but then you're saddled with potentially a limited challenge, or that you just sit back and kind of hope nothing goes wrong. Interestingly, though, I know this debate is being replicated absolutely everywhere. And I think Bernard's right. I think it's the single most important proposal. And it's certainly the one on which people hold the strongest views.
And I'm not sure we've helped at all.
No.
Can I just ask panel members one other aspect of this? I mentioned that the proposal is to make section 67 challenges by way of review, but not to make any change to the way in which a section 103 determination is made in relation to an award, an incoming award, if I can put it that way. Does anyone have any comment on that aspect of it?
It's another wrinkle. That's the problem. It's not changing it. That's all I would say. It's an argument in favour of keeping section 67 as it is. I mean, the world falls into two different kinds of people: those who like consistency and those who like inconsistency, or who don't mind inconsistency. And it often says that consistency is for dullards. And if that's so, then let's all be, what's the opposite of dullard, but opposite of dullard.
All right, thank you very much indeed. We'll move on. So the... What am I doing? Okay.
69.
Yes, right. Appeals on a point of law, where, as you probably know, the Commission is proposing no change in relation to section 69 of the Act, on the basis that it is minded to think that the section currently strikes the right balance. So I'm going to go to Bernard first on this, and I'll ask you as part of that, if you wouldn't mind, to just say a word on the obviously wrong part of this test, which reading the NEMA, one might have thought meant something rather extreme, in the sense that the award is blatantly ridiculous as soon as you pick it up, but I suspect is not applied in practice in that way in the commercial court, at least at present.
Well, can I start with a bit of history just for a moment? Because if you look back at arbitration over the last, say, 50 years, the idea that you can not challenge an award other than on a question of law with leave is quite novel. So in the NEMA, which I was involved in, I'm going to say almost 50 years ago, but it's probably over 40 years ago, something like that. The argument that we ran, or was run against us by Bernard Ricks at first instance, and the NEMA on the facts, this is a case in 1979, the NEMA on the facts was a case about frustration by a strike. And the arbitrator held that the charter party was frustrated by a strike because the likely prognosis was that the strike would go on for a very, very long time. So held by the arbitrator, charter party frustrated. The award came out, I think, on the 22nd of September, 1979. And on the 23rd of September, if I remember rightly, the strike came to an end. So his findings of fact were proved wrong by, I'm not sure history, but by future history. So the question, so the other side applied for leave to appeal under the new 1979 Act in that case. And we said that the question of frustration was a mixed question of law and fact. It was not a question of law. It was a mixed question of law and fact. Robert Goff shouted at us. Now, Robert Goff was one of the cleverest, mildest mannered men you could possibly imagine. And if you read his judgment at first instance, he said something like, the argument that we raised, that it was a mixed question of law and fact, was an old warhorse of an argument that should never have been let out of the stable and should be put back in the stable and locked up and never let out again. Held by Lord Denning in the Court of Appeal that Robert Goff was wrong, and by Lord Diplock in the House of Lords, I'm going to use the words obviously wrong. And so the idea that you can only get leave to appeal on a question of law and other things as well, other limited, is quite dramatic, very, very dramatic. The other important thing is we are the only country in the world, actually, which allows an appeal on a question of law in an international way. Sometimes there are some jurisdictions that allow it in domestic. We're the only country in the world about that. And it was, we decided in 1979, 1996, to maintain the position and not to follow UNCITRAL. UNCITRAL effectively does not allow any challenge, any appeal on a question of law. So to that extent, England stands unique. We are the only jurisdiction in the world to allow that. We allow opt-outs, of course, so the LCIA and the ICC allow opt-outs, so that restricts the number of appeals. So that is the history of that. And the question is it, should we retain it? And views, I think, have narrowed considerably. In the early part of the years in 1996 and onwards, there was great controversy, I think, as to whether or not the Act was too restrictive in allowing leave to appeals. And I showed it to Andrew. Anyone who's interested, when I was a judge sitting in the commercial court, I produced this chart, this flow chart. In order for a judge sitting in the commercial court to give leave to appeal, the judge has to go through about 20 different specific steps and consider each one before he gets to the end, where even if he gets through all the hoops, he or she gets through all the hoops, there's still a discretion to say no leave to appeal. So anyone who wants that, very, very welcome. So it was a very controversial topic. It was also controversial because there was some uncertainty in the early years about how the discretion was going to be exercised. And there was a great view, it went too far one way and the other. And in fact, it moved a lot. It was almost like a pendulum. I'm talking about the late 1990s, early 2000s. Everything has now settled down, I think. And trust the judges, that's what I say. trust the judge. And I think, I'd be very interested to hear, but my own view is it generally works very, very well. And I agree completely with the Law Commission on it. Leave well alone, do not touch it. Don't touch the leave to appeal and don't touch anything else. Having said that, there are some interesting problems. So for example, let me give you a specific problem. There was a judgment of Mr. Justice Flo, I think in the Astra some years ago, where he held that failure to pay hire under a charter party constituted effectively a breach of condition, entitling the ship owners not only to withdraw the ship, but to claim damages on a repudiation basis. So if a charterer fails to pay hire 1 minute past midnight on a 10-year charter due to a banking error, for example, the owner can obviously withdraw, held by Mr. Justice Flo that the owner is also entitled to repudiation type damages for the full 10 years. So held by Mr. Justice Flo. There were then a lot of arbitrations in the city following that. I think that was 2013, where they all said, well, that may be right, it may be wrong, but that's what the judge holds, and we are therefore bound to follow that. So there are a whole lot of arbitrations which followed Mr. Justice Flo. Then it comes before the court on an application for leave to appeal. Now, is it a point of general public importance? Yes, it is, I think, probably. And on the two tests, let's say on the two tests, but is it open to serious doubt? Well, Mr. Justice Flo has held that it is a breach of condition. Can that possibly be said to be open to serious doubt? And a number of applications for leave to appeal were refused on the basis that Mr. Justice Flo, it could not be said that he was open to serious doubt. Even on the higher test, obviously wrong. Well, it can't be said he's obviously wrong because he's a judge of the commercial court. So on both counts, leave to appeal was refused. And case came forward a few years later called SPAR, I call it SPAR Shipping, which was not an arbitration case. It was a claim under a guarantee, not governed by an arbitration. And it went to the court, therefore, and didn't have to go through arbitration, and the Section 69 held in the Court of Appeal that Mr. Justice Flo was wrong. And from 2015-16 onwards, therefore, because the case came to the court not through the arbitration route, the court was able to deal with it without having to deal with the obviously wrong test. Now, I mention this because this created real unfairness. There are a number of cases where charterers had to pay repudiation damages because the test in the Act was applied. And this arises whenever, this arises whenever you have a first instance judgment that may be debatable, or I say may be debatable. And so this is a problem. Is it a real problem? Not really, I don't think. But I was at a meeting earlier today where Lord Mance was very keen on widening the scope of the application for leave for appeals. He said at the moment it's too rigid, and he would favour a more, I'm not sure, flexible approach. I am completely against that, I have to tell you. I think widening that would be bad. And some of you may remember Lord Thomas a few years ago made a speech that complained that because of the restriction within Section 69, within the application for leave to appeal, there weren't enough cases getting to the court. And this was stultifying English law. And therefore he made a speech saying it should be widened for that reason as well. I was very much against that. Lord Savile wrote as well, and I gave a speech as well. My own view is, from an international perspective, that would be a very bad thing, capital B, capital T. I think that my own conclusion is exactly the one reached by the Law Commission, and that is that that you just leave well alone. There are other problems. If I've just got 2 more minutes, just so I don't want to talk about it much, but I've been an arbitrator in 4 cases where the same issue arose. In 2 of them, I was part of the majority, and in 2 of them, I was effectively overruled by the majority in the 2 cases. And the question in those circumstances, if you look at each individual, it was on a one-off clause. So the test on the one-off clause is it obviously wrong? Well, if you look at each individual case on its own, I don't think it can be said. I mean, I was in the majority. I decided the same. My reasoning was the same. So my reasoning was not obviously wrong in any of the cases. But the question on each case is, in each case, was the reasoning of the majority obviously wrong? And although the 2 cases went one way and 2 cases went one way, you couldn't say that any one case was obviously wrong. But I always remember Michael Mustell saying, well, there are times when a judge just has to make a fudge. And leave to appeal was granted in all those 4 cases, I am told. We all wait with bated breath as to what the answer may be.
Thank you.
So
I think in addition to fudge, there is also a glass of claret test lurking
Yes.
somewhere.
Yes, that's right. So the obviously wrong test is a wonderful speech, I think, given by Mr. Justice Coleman,
Yes.
where he says, what does obviously wrong mean? Does it mean that you read the clause 10 times and look at it very carefully and come to the conclusion it's wrong? Or do you mean, I hope I've got it right, with a glass of Chablis, I think, in your hand, and you just look at it and you say yes or no, something like that. And he says, I rather think the latter, he says.
Thank you. Any other panel views on that one?
So my view is on section 69,
Yes.
keep it exactly as it is, trust the judges on application for leave, and leave things well alone.
I'm sure everyone's in favour of that. Any other views on that?
On your point about the Astron, am I going mad with the eternal bliss, which is going the ways of the Supreme Court now? Am I right that it only got to the first instance despite the authorities against it because the parties agreed to have the point of law determined by the commercial court rather than by the arbitrators? Then it would have got there.
Oh, I see, wouldn't have got there.
I might be talking rubbish, but I have this vague recollection.
Who now? What a suggestion.
All right, any audience questions or observations? Yes.
Yes, I'm probably about to commit heresy. This is something I've been advocating for years to anybody who cares to listen. I'm struck by Philippa's point earlier about some people in the international orbit might be reluctant to arbitrate in England because the courts may interfere too much. And Sir Bernard's mentioned how unique England is in having Section 69, appeals on the point of law. And I must admit, when I look at what arbitration is about, it's about the parties wanting an efficient and certain resolution of their dispute. And I must admit, I've never been convinced that Section 69 is necessary. There's a reason Ulcitran doesn't have an equivalent, why the LCIA rules effectively don't have an equivalent. It's occurred to me that if Section 69 became an opt-in rather than an opt-out provision, I wonder how many parties would opt in. I suspect very, very few. And I think that is an important consideration.
Thank you very much. Then the gentleman at the front and then over there. Thank you.
Well, I have questions for you. Is it possible to have finality of the arbitration clause without any appeal on a point of law whatsoever? Is it possible to draft the arbitration clause in such a way?
You opt out. You just say there shall be no leave to appeal, or there shall be no appeal, or something like that. You can.
Is it possible to?
Absolutely.
Good.
It's a non-mandatory provision. You can opt out of it. I'll happily answer your gentleman's question. It's quite interesting for a number of reasons. One, if you look at the statistics, and that's important, how many cases actually get to the court on a Section 69? And I think it is something like 0.01%, something of that kind. The second thing to mention actually is that the real drivers for Section 69 are the shipping community. I mean, historically, they are the ones who wanted it in and still want it in. And again, if you look at the statistics, I happily share it with you, something like, I'm trying to remember, something like 2/3 of all Section 69 appeals are shipping cases. And it's driven by the shipping community. The non-shipping community who go to, for example, the LCIA or the ICC or whatever, all opt out. So in answer to your question, if the position were changed to make it an opt-in rather an opt-in, I rather suspect that in reality, nothing, in terms of the statistics, nothing much will change.
Right, sorry.
My understanding is that quite a lot of the commodities associations like it as well. So not shipping, but commodities, which of course is allied, where their tribunals are typically not lawyers. But nonetheless, every so often, a really difficult legal point will come up. And for them, Section 69 can be quite valuable. And as Bernard says, if you don't like it, well, adopt the LCIA rules, adopt the ICC rules. You don't have to do it.
Take an example, a very recent example, whether under the Hague rules, I speak to a shipping community, misdelivery of cargo to a third party after discharge, whether the Hague rule time limit applies to that or not. There's a decision of Mr. Justice Foxton that touches on that. I sat with two other arbitrators, made an award upheld by Mr. Justice Blair on that. And it's an interesting point because Scruton on charter parties goes one way, Carver goes another way, and I think two other major textbooks go different ways. And the three members of the tribunal were all editors of the different textbooks, I should tell you. Anyway, it's gone to Mr. Justice Blair. Mr. Justice Blair has in fact held that the time bar does apply. That's a public judgment, I can tell you that. But he gave leave to appeal to the Court of Appeal, very unusually, I think last Friday or the Friday before, very recently, I hope I get the date right. So, and that's why I think that kind of problem, I don't know here, I've done a number of cases of that kind, and different arbitrators have reached different conclusions on that. And inconsistency, going back to what I said earlier, is in that situation very unsatisfactory on a substantive issue of law. And the decision of Mr. Justice Blair will now be because what I've just said is there are not only in the textbooks, but there are different cases in different jurisdictions reaching different conclusions, dealing with shipping community worldwide. So we now have an actual decision of the English court on that issue. And so I'm very much in favor of it in the limited, very tight circumstances that govern applications for leave under Section 69.
Right, thank you. We had one more question over there, I think.
With regard, I was very interested to hear the history of the Astra and then Spa shipping, but is not part of the moral of the story that judges of the High Court should be more willing to consider that their brethren might be wrong, and that the decision of, say, another judge of the High Court might be open to doubt?
Well,
in other words, keep the wording, but relax the interpretation a little, or at least relax the law of precedent a little.
I think it's become more relaxed than it used to be.
Yes.
I think we're willing to contemplate that Mr. Justice Flo was wrong and may even now still occasionally be wrong now that he's Chancellor of the High Court. I think you're right that the test does have to be applied with a degree of common sense, and the fact that there is a decision, whether it's a binding decision or a decision at first instance, doesn't necessarily mean that the position is not open to serious doubt. Otherwise, the law would never move on. All right. Well, thank you very much. We'll go on to the next topic, which is law governing arbitration agreements and separability. So let me just, by way of introduction, say, as we know, an arbitral award occasionally may turn out to be a complete dead letter if what's happened is that the issue raised by the parties, for example, bribery, repudiatory breach, misrepresentation, has gone to the root of the contract, to use an old-fashioned phrase, and the arbitrators conclude that the contract has fallen away. Well, that's fine if the law applies severability so that the arbitration clause still survives and the award is valid, but what if it doesn't? And so one of the questions the Commission asks is whether the principle of severability, which is in Section 7 of the Act, should be made mandatory. But there's a link, of course, between that issue and governing law, because it's been held that the Section 7 severability is one of the things that is non-mandatory in the Act, and that non-mandatory parts of the Act may not apply if the law governing the arbitration agreement is not English law. And hence we get to the discussion in the Enker case about whether the law governing the arbitration agreement should be assumed to be the law of the main contract or the law of the seat. So I'm going to go to Philippa first and begin by asking whether she thinks there's a problem or not, and if so, how it should be addressed.
Well, before I answer that, I'm going to reveal that when we had a pre-meeting about this seminar, Andrew said, all right, who's going to take separability and governing law? And there was a very long silence. And eventually I said, oh, okay, I'll do it. And I still think I might have drawn the short straw because I think this is difficult. Is there a problem? I will come on to that. I think there are potentially several problems. I'm not sure they're necessarily problems that need to be fixed. I think it depends on how you define your problem. Andrew's mentioned both separability and governing law. And of course, the two are related. The Commission has suggested that perhaps separability ought to be made mandatory so that it's not, Section 7 is not a section out of which people can contract. As I read the report, they are a bit agnostic about the right answer on that at the moment. They say it's probably not necessary, but if people feel strongly, then all right, maybe it's a good idea. I think I'm a bit agnostic about it too. And the reason I'm agnostic about it is I don't think it answers what is a more interesting question to me, and that is the governing law question. That has to do with separability, but separability is often not the answer. Now, it's perhaps worth scrolling back a bit and reminding ourselves very briefly what the present state of English law is in the light of Enker and in the light of Kababji, two decisions of the Supreme Court. And they're long decisions, particularly Enker. Enker gives you 9 principles which you should apply when considering this interesting question. But for present purposes, and really trimming it down, what we're talking about is this. Enker says, where there is an express choice of governing law in the main contract, that will generally also be construed as extending to the arbitration agreement, which, though separable, forms part of that contract. And the choice of a different law as the law of the seat, that's to say, we're choosing LCIA arbitration in London or LMAA arbitration in London, will not by itself negate that inference. They go on to say, absent an express choice of law for the contract as a whole, the law of the arbitration agreement will usually be that with which the arbitration agreement is most closely connected. You have to ask what that law is, and it's usually going to be the law of the seat. So where you get to is choice of law in the main contract is usually going to be construed as covering the arbitration agreement as well, and so being the proper law of the arbitration agreement. No choice of law in the main contract, but a named seat, proper law of the arbitration agreement, usually the law of the seat. It all gets a bit existential at times, frankly. So does it matter? Well, it can. And how it can was brought into very sharp focus in the Kebabji case. And that concerned the enforceability of an arbitration award rendered by a French tribunal. The main contract had an express choice of English law. The arbitration agreement provided for ICC arbitration in Paris. There was no express choice of law governing the arbitration agreement itself. Frankly, how often have we seen those? I think I've seen one or two long arbitration clauses which say this arbitration agreement is governed by English law or French law, whatever. You don't often see them. The issue in that case was as to whether the respondent was party to the arbitration agreement and therefore whether the French tribunal, which had rendered its award, had jurisdiction at all. Applying English law, so the law of the main contract, to the arbitration agreement, the answer was no, the respondent was not a party to the arbitration agreement. But applying French law, the law of the seat, the answer was yes, it was a party to the arbitration agreement. And you can see how this played out if you don't know already. The Supreme Court here said, yep, applying ENCA, English law applies, respondent not a party, award not enforceable. Off you go. But the French courts, up to and including the Cour de Cassation, which handed down its judgment just a few weeks ago, have said, no, we find that it's the law of the seat that applies to determine the law of the arbitration agreement. That's French law, as we all know, so the award is valid and enforceable. So what you've got is, at least in that case, a very stark difference. And it's a very stark difference between two sensible, grown-up legal systems, both of which recognize separability. Is this a problem that something should be done about? Well, there are some who think that indeed there is such a problem and that the Act should do something about it. And I've had several of them bending my ear recently. And there is a view that ENCA is just wrong and that there should be a provision in the Act to the effect that the normal inference or presumption should be that the law of the seat is the law governing the arbitration agreement. And interestingly, as some of you will know, the Scottish Arbitration Act does something pretty similar. It does provide for exactly that as regards arbitration seated in Scotland. The Law Commission has said, and has said in quite brief terms in the report, we don't think we should be interfering with this. And they give a number of reasons for that. They're particularly concerned, I think, that the Act doesn't currently deal with conflicts rules at all. So this would be a departure. Set against that, well, the thing is, set against that rather depends on what you think of ENCA, doesn't it? If you think ENCA is really terrible, and there is, as I say, a vociferous contingent at the commercial bar that thinks it is really terrible, then you might think, well, it's worth doing something about it. Personally, and at risk of being shouted at by some of you, I'm not so sure that ENCA's that bad. I don't understand it to be the case that all other jurisdictions take the same line as the French, and we are just completely out of step. My understanding is that this is a difficult issue and that there are jurisdictions in both camps. It also seems to me that ultimately either position is really a bit of a construct, isn't it? The Supreme Court in ENCA say, well, there is an implied choice by the parties that the law of the contract should govern the law of the seat. They don't really think that the parties actually sat down and thought about this. Of course they don't. And I think the giveaway to the fact that they don't really think that is that the Court of Appeal in ENCA said exactly the opposite. So the Court of Appeal said, if you choose London as your seat, you are making an implied choice that the law of the arbitration agreement is English law, because that's the law of the seat. So I think either way, it is a construct. I think there are arguments to be said on both sides. I don't think either position is obviously wrong, and indeed at risk of sounding like Bernard or disagreeing with what you said about Mr. Justice Flo. in circumstances where you've got a very strong Court of Appeal, Lord Justices Popplewell, Males and Flo going one way on this, and a very strong Supreme Court, including the Lords Sales, Hamblin and Leggett, going the other, it's a bit difficult to say ENCA is obviously a complete disaster and completely wrong. All that said, I expect the Law Commission is going to hear a good deal about this, and I think that that is probably right. I think it's something that requires ventilation, and it's probably a little bit unfair to say, well, we think it's probably not broke, don't touch it. I think it's a tricky one, this one.
Yes, I think it's important to bear in mind that the question when we're looking at law reform is not whether ENCA was right, but whether it's the rule we want. And I think that's the debate, which, as you say, is quite going on in quite a lively fashion at the moment. Do any other panel members have a view on this point?
Do we know, Philippa, how many jurisdictions do what? Because the real thing we want to do is achieve consistency. The debate really doesn't matter. It's where the what's the case called?
ENCA.
No, the other one.
The other one, Kababji.
Where you get the inconsistent results.
As that, there is a survey in both Kababji and ENCA, whether it's correct or not, I don't know, which I think it's probably fair to say that the majority view may be slightly on the French side, but there are plenty of substantial and serious jurisdictions that take the same approach as we do. And if that's right, I think, yes, on one view, on a policy level, you want to kind of max out consistency, and the alternative doesn't look good. But I think there is always going to be some inconsistency somewhere. The New York Convention allows states to form their own view on questions like this. And they're not always going to form the same view. The French view, as I understand it, derives from a very, very strict view of separability, which almost entails them disregarding the main contract when it comes to looking at how you approach the arbitration agreement. And we do separability too, but they do it in a rather more compartmentalized way than we do, I think.
Might I be mischievous and suggest, I think Andrew is absolutely right. Forget about whether ENCA is right or wrong itself. I think the question is what ought to be the rule. And I think we should, I'd be interested to put it to the vote if I had my red or green. Should we in England have I'm going to say a general rule that where parties choose the seat, then there is an implied choice of law of the seat to govern the arbitration agreement. Is that fair? Have I summarised
I think so, yes. Let's have hands up for that, if anyone agrees with that view.
Oh God, not fair.
I wasn't going to vote. I was going to remain scrupulously impartial.
There can be no voters here. You've got to either vote one way or the other, because alternatively we'll have no resolution of this at all, which is unacceptable. So who's in favour, obviously, right, who's in favour of the rule that if you choose the seat, you choose the law of the arbitration?
Yes, they're going up gradually.
Yes.
As they gain confidence.
Be brave. Fortune favours the brave.
Anybody, all right, anybody who disagrees, who would not have that rule?
Carried overwhelmingly. Oh. Fairly balanced.
No, they're not here.
I'm not sure how logistically I would do that, but
Raise your hand.
I get a sense of the division in the room, certainly. All right, thank you very much. Any audience comments or questions arising from that? Yes.
Thanks. Isn't the problem really one for the ICC? I say this because both ENCA and Kababji arose from ICC arbitrations. The ICC rules have no default provision for the law of the arbitration agreement. In contrast, the LMAA terms provide that absent any other agreement, the law of the arbitration agreement shall be, guess what, English law. Now, my question for the panel would be whether that provision in the LMAA terms, if incorporated
in an arbitration clause in a charter party, which would simply provide under the ordinary BIMCO dispute resolution clause that the LMA term, the arbitration should be conducted under the LMA terms, whether by incorporating the LMA terms in the arbitration agreement, isn't that an express choice of the law of the arbitration agreement, regardless of whether or not the charter party itself is subject to English law? And isn't that the solution? You don't have to put the law of the arbitration agreement into your arbitration clause if you've adopted sensible rules which deal with the situation.
It's certainly the case that you can deal with this by contract. And perhaps interestingly, when I was doing a sort of poll on the solicitors' websites reporting on ENCA, they almost all end up by saying, of course, the way to deal with this is to put something specific in your contract or to put something in your rules which cover it. And it may be that that's actually where we end up, to the extent that there are real concerns about this. They're actually not best dealt with by tinkering about with the Act, but by dealing with it by changing the institutional rules, if that's what's thought most appropriate. And of course, it is always open to parties to stipulate expressly the law that governs their agreement. And then I think all jurisdictions are agreed that there's no problem. That's what you do. That's what you've chosen. And your choice will be respected.
Yes, well, it's certainly the answer where institutional rules like that are chosen. I think the problem arises in relation to all the arbitration agreements that don't do that. And I'm sure there always will be many arbitrations that don't make such a choice, and many institutional rules which don't expressly deal with the law governing the arbitration agreement in the way that the LMAA rules do. I suppose if there isn't a change, then that may lead to other institutions taking the view that they should follow suit. All right, thank you very much. We'll go on, keep an eye on time. We've got two other topics, but I think we can take them pretty shortly. The first one is summary disposal. And in a nutshell, the proposal is that the Act should explicitly say that arbitrators can use a summary procedure to dispose of a claim or defence. The procedure would be a matter for the arbitrators, and the Act would specify the test. And the Commission's current proposal, or minded to proposal, is to effectively use the summary judgment test that's applied in the English courts. So I'll go to Bernard first on this.
Very, very quickly. There is a theoretical problem or a philosophical problem, in the sense that if you look at Section 1 of the Act, it contemplates that one of the principles is the fair resolution of disputes. And the focus is on resolution of disputes. And I remember Michael Mustall telling me that the job of the arbitrators, and when we were considering this many years ago, the job of the arbitrators is to determine disputes. It's not to decide that there is no real prospect of an argument succeeding or not succeeding. And it goes against what the fundamental task of an arbitrator is. So there is that philosophical question anyway. I'm not sure it answers everything. The second point, just simply to make, is that I think most of arbitrators think you've got that power anyway by a different route. You can do preliminary issues. So you can, if you think that a case is hopeless on a particular point, then you've got that power anyway. And again, that I don't think that really goes that far because having a preliminary issue, you've got to actually determine the dispute again itself. So I think there is an argument in favor of it. Another point that was made earlier today was that the concept of summary disposal is very much an English common law concept, and foreign parties would not like that. They come to London to have, it goes back to my first point, to have their disputes determined. They don't come to London to have their disputes dealt with on the basis that on a possible argument that one point is hopeless. And finally, the last point I would make is I would be concerned because you've got to look at the ramifications of this. That there is no possibility of a challenge to such a decision unless you can go through one of the three gateways. Jurisdiction doesn't matter here. Appeal on a question of law may not matter at all, or serious irregularity. So you're looking to a situation where a tribunal may decide that a claim is hopeless. I'm using that word very generally. There's no realistic prospect of success or something like that, where there's no possibility of review at all. So for those reasons, I would move very cautiously. And so I would probably be against the suggestion of summary disposal.
Thank you. Other thoughts from the panel?
I'm desperate for this proposal to go through. I'm tired of arbitrations going on with really bad points being taken all the way to the end. And I agree that with the preliminary issue ability, tribunals could knock some of these out earlier, but they're loath to. And there is this due process paranoia of which lots of users complain. And so I'd like to see it come in. We'll see. The tribunal can be careful in light of your point about Section 1 as to how often it is suitable to be used, and it will evolve with time. But there is a fear, I think, in the arbitral community at the moment that the power is not expressed. Preliminary issues different. It's determining something X or Y rather than chucking it out early on summarily. And I think having the power would lead to a lot of very bad points being got rid of.
What would you put as the test?
Oh, I'd have this because we understand it. I don't have too many tests.
But how many, not sure I'm going to have a vote. I agree with everything you say in a way, but I'm always just a bit cautious on this. I speak for myself. How many cases have you done where someone has said the point is hopeless and you have won or the other side has won? And I don't know, my life is littered with failures that I thought we would win and also successes that I should never have won at all.
But hopeless is a high term. I mean, there's lots of, I'm going to lose at. It's a very difficult case, but hopeless.
I did one case.
I'm with Poonam on this, I have to say. I think hopeless, I think you could different ways of wording it, but we've all had those cases where you think, what am I actually going to argue on this? It is so bad.
It's the red-face cases.
The red-face cases.
And we're still there doing it on the last
correct.
day.
And I do think that fairness, the duty of fairness under Section 33 does not necessarily import a full hearing.
Do you think the English test would be internationally understood and appreciated, or should it be something different?
There is a suggestion that the wording should be different, isn't there? And I can't remember what it is in the report at the moment.
Well, a lot of, yes.
International.
Yes.
Manifestly without merit. I'm not sure I understand the difference between the two, but if it's more internationally palatable, well, great.
All right. Any audience comments or thoughts on summary disposal? Yes.
Yeah, just I fully agree with Poonam. We see, unfortunately, too many poor arbitration cases being run, and arbitrators don't use the preliminary issue route, which they could do, but in practice they don't.
He does.
Oh, okay. Some do. Good to know.
We'll do
Thank
it
you.
Monday morning.
Thank you very much. And one more over there, I think.
Sorry, you can't do preliminary point if the parties don't agree. You try to persuade them, but they don't want it.
Sorry, who don't want it?
The parties
The parties don't.
can't impose on them that you can do that.
All I would say is that it would take a very brave arbitrator, particularly in a sole arbitration, to take advantage of this. You really feel that one really feels that one has to give the parties the opportunity to make their case, however weak it seems early on.
So do you think perhaps writing it into the Act would encourage people to do it?
Possibly,
Nervous sole
yes.
arbitrators. Yes.
I don't know. I wouldn't like to have it there.
Right, thank you very much. All right, well, last topic, immunity of arbitrators. I will simply ask Bernard, should arbitrators always be immune?
Well, the answer is they should always be immune for whatever. But I think, I mean, the arguments go both ways again. It is suggested that if you don't give arbitrators complete immunity, there is always a fear that they may do things to avoid the possibility of being sued. I mean, that is a possibility. But I think the general view, everyone I've spoken to so far, everyone is in favor of complete immunity. That the real question at the moment is there are a number of cases, I think there are 2 cases, where the suggestion is that an arbitrator may be liable for costs in certain circumstances. So, for example, tested by an absurd example, on a Friday evening, with a 2-week hearing coming up, an arbitrator decides to go on holiday for 10 days, or being offered a more lucrative arbitration appointment in some foreign part, and just decides I'll earn 10 times more if I go to this country and do it. Should he be? And then the arbitration the following 2 weeks has to be abandoned to get in a new arbitrator. Should the arbitrator in those circumstances be liable? My own view is that there should be a residual power to order some kind of costs order against arbitrators, limited to certain circumstances. And I think we leave the Act well alone and trust the judges. That's what I would say.
I'm not going to dissent from that one. Any other panel thoughts on immunity? No, audience? All right, well, thank you. We'll leave it there. So can I thank our wonderful panel for such a stimulating and interesting discussion. Thank you, London Shipping Law Centre, for organising this seminar, including everyone involved. But can I mention Dr. Aleka Shepherd, our founder and chairman, Vasanti Selvaratnam, KC, and Gerard Matthews for putting together such a really excellent event. And thank you to the IDRC for hosting us here this evening. And thank all of you for coming along and participating very actively in this discussion. So we can now continue, I think, over drinks. Thank you all very much.